You're a California landlord who just collected rent from a tenant you've never had problems with. 3 weeks later, a $47,000 lawsuit lands on your doorstep. The reason? A leaky faucet you didn't even know existed. Sound impossible? It's happening right now under California's new 2026 tenant protection law. And thousands of landlords are getting blindsided. One property owner in San Diego just lost $83,000 over what his insurance company called routine maintenance issues. Another landlord in Sacramento is facing bankruptcy because she couldn't prove she responded to a complaint fast enough. Here's the terrifying truth. You could be next, and you might not even see it coming. The old rules you've been following for years completely useless now. That lease agreement your lawyer drafted won't protect you. I'm about to reveal 10 hidden traps in this new law that could financially destroy your rental business overnight. If you own rental property in California and you're not subscribed to this channel, you're literally gambling with your financial future. I'm giving you legal insights that attorneys charge thousands of dollars to explain, and I'm doing it for free. Hit that subscribe button right now. This isn't a suggestion. This is your wake-up call. Number 1, expanded definition of habitability violations. Let's start with the most dangerous change that's catching landlords completely off guard. California's 2026 law has dramatically expanded what counts as a habitability violation. And this is where the $25,000 lawsuits are piling up faster than you can imagine. Here's what you need to understand. Under the old system, habitability violations were serious things. No heat, no water, structural damage that made a unit unsafe. But the new law, it's opened the floodgates. Now, things you'd consider minor annoyances are legally classified as major violations that trigger massive penalties. We're talking about a slow draining sink, a flickering light fixture, inconsistent water pressure, or even minor cosmetic cracks in walls. Yes, you read that right. A tenant can now claim these reduce their quality of life and sue you for tens of thousands of dollars. Let me give you a real-world example that'll make your blood run cold. A landlord in Los Angeles had a tenant complain about a bathroom exhaust fan that was too noisy. The landlord thought, I'll get to it next month during routine maintenance. Big mistake. That tenant documented the noise, claimed it caused sleep disruption and stress, and under the new expanded definition, it qualified as a habitability issue. The lawsuit, $32,000 in damages plus $18,000 in attorney fees, a $50,000 total loss over a noisy fan. Here's the critical shift. The law now includes anything that affects a tenant's peaceful enjoyment of the property. That's an incredibly vague and subjective standard that gives tenants enormous power. A drafty window, habitability violation, inconsistent hot water, habitability violation, peeling paint in a closet, you guessed it, habitability violation. What you must do right now, create an updated inspection checklist that covers every single detail, no matter how minor it seems. Walk through your properties with fresh eyes and ask yourself, could a tenant claim this affects their comfort or enjoyment? If the answer is maybe, fix it immediately. Document everything with photos, timestamps, and written records. In this new legal landscape, prevention is your only protection. Because once that lawsuit is filed, you've already lost thousands in legal fees alone. If you haven't subscribed yet, you're choosing to lose money. I'm giving away legal secrets. Attorneys charge thousands for free. Subscribe now. Number 2, tenant self-help repair rights. Now let's talk about what I call the repair and bankrupt provision. And this one is absolutely ruthless. Under California's 2026 law, tenants now have supercharged self-help repair rights that can turn a $200 fix into a $30,000 nightmare before you even know what hit you. Here's how this legal trap works. If a tenant reports a maintenance issue and you don't fix it within what the law calls a reasonable time frame, which is intentionally vague and undefined, the tenant can now hire their own contractor, get the work done, deduct it from rent, and then sue you for the difference plus damages, penalties, and emotional distress. And here's the kicker. The tenant gets to choose the contractor, and there's no requirement that they get competitive bids or use reasonable pricing. Well, let me paint you a real scenario that's happening across California right now. A tenant has a minor plumbing leak under the kitchen sink. You tell them you'll send your regular plumber within 5 business days, which used to be perfectly reasonable, but the tenant doesn't want to wait. They hire an emergency repair specialist who charges $1,200 for a job your plumber would have done for $150. The tenant deducts that $1,200 from rent, then sues you, claiming the leak caused anxiety, damaged their belongings, and disrupted their daily life. Total lawsuit value $28,500. Here's the nightmare clause. You can't even argue that their contractor overcharged or that you are already planning to fix it. The law says if the issue qualified as a habitability concern and you didn't fix it immediately, the tenant's self-help action was justified. You're now defending a lawsuit where the tenant has all the leverage and you're stuck paying their inflated repair bills plus damages. Your survival strategy: respond to every maintenance request within 24 hours, even if it's just to acknowledge it.
Keep a pre-approved contractor list with guaranteed response times. Send confirmation text and emails proving you're taking action. The moment a tenant reports anything, treat it like a potential lawsuit. Because under this new law, that's exactly what it is.
Not subscribed? You're literally funding your own lawsuits. This channel saves landlords millions yearly. Hit subscribe before your next tenant does. Number 3, retroactive claim period extended. Hold on to your wallet, because this next provision is a legal time bomb that could explode in your face at any moment. California's 2026 law has tripled the look-back period for tenant claims, and landlords are getting ambushed by violations they thought were ancient history. Here's the devastating reality. Tenants can now reach back 3 full years to file habitability claims instead of the old 1-year limit. That means every maintenance issue, every delayed repair, every complaint you handled from 2023, 2024, and 2025 is suddenly back on the table. Think about that for a second. Problems you fixed years ago still fair game. Tenants who never complained at the time, they can claim damages retroactively. Or even tenants who have already moved out can come back and sue you for issues from their entire tenure. Let me give you a chilling example that's playing out right now. A landlord in Fresno had a tenant move out in mid-2024. Everything seemed fine. No complaints, no drama. Security deposit returned without dispute. Fast forward to January 2026. That same tenant files a lawsuit claiming that back in early 2023, there were persistent moisture issues in the bathroom, a malfunctioning thermostat, and inadequate weatherproofing that the landlord ignored. The landlord has no documentation from that period because, frankly, who keeps detailed records from 3 years ago for a tenant who left without issues? The lawsuit, $41,000 in accumulated damages, penalties, and attorney fees. Oh, here's what makes this absolutely terrifying. You're now defending yourself against claims from a time when different laws applied with incomplete records, fading memories, and possibly contractors or vendors who are no longer in business. The tenant, meanwhile, can craft a narrative that's nearly impossible to disprove because of the time gap. Your emergency action plan: immediately audit every property's maintenance records for the last 3 years. Identify any unresolved complaints, delayed repairs, or tenant communications you can't fully document. Create a comprehensive file for each property with photos, work orders, receipts, and written correspondence. If you find gaps, consider proactively reaching out to current tenants to address any lingering concerns before they become lawsuits. Ignoring this channel means ignoring $50,000 lawsuits heading your way. I'm handing you the playbook lawyers won't share. Subscribe immediately. Number 4, emotional distress damages now included. Buckle up, because this is where California's 2026 law gets absolutely insane. For the first time in landlord-tenant law, tenants can now claim emotional distress damages. And this single provision is turning $5,000 cases into $50,000 nightmares. Here's why this is pure legal dynamite. Unlike traditional property disputes where damages had to be tangible and measurable, like actual repair costs or relocation expenses, the new law allows tenants to claim they suffered mental anguish, anxiety, depression, stress, and emotional suffering because of habitability issues. And here's the terrifying part. These damages are completely subjective. There's no formula, no cap, and no requirement for medical proof. A tenant simply has to claim they were emotionally harmed, and suddenly your exposure multiplies exponentially. Let me show you how devastating this becomes in real life. A landlord in Oakland had a water heater malfunction that left the unit without hot water for 4 days while waiting for a replacement part. The actual repair cost $800, but the tenant claimed those 4 days caused severe anxiety about hygiene, embarrassment, canceling social plans, and ongoing stress affecting work performance. The jury awarded $22,000 in emotional distress damages alone, plus the repair costs and attorney fees. Total hit to the landlord, $38,000 for a 4-day inconvenience. Here's the nightmare scenario you need to understand. Even when you fix problems quickly and professionally, tenants can still claim the temporary disruption caused lasting emotional harm. A noisy HVAC system that took 2 weeks to replace. Tenant claims sleep deprivation and anxiety, a persistent odor from a neighboring unit you couldn't immediately identify. Tenant claims daily stress and fear for health, mold discovered and remediated within days. Tenant claims ongoing trauma and panic attacks. Your critical defense strategy: Document everything with timestamps showing your rapid response. Keep detailed logs of every communication proving you took complaints seriously and acted immediately. Consider requiring tenants to submit maintenance requests in writing so you have proof of when issues were reported versus resolved. Most importantly, maintain compassionate professional communication that shows you care about tenant well-being, because those text messages and emails will be read in court. Still not subscribed? POTS, you're gambling your entire portfolio on outdated advice. Get the protection strategies that actually work. Subscribe now. Number 5, reduced burden of proof for tenants. Here's where the legal playing field gets completely tilted against you, and most landlords don't realize it until they're sitting in court watching their defense crumble. California's 2026 law has drastically lowered the burden of proof tenants need to win, and this change alone is responsible for landlords losing cases they should have won. Under the old system, tenants had to provide clear and convincing evidence that a habitability violation existed and that you failed to address it. That was a high bar that protected landlords from frivolous claims. But now, tenants only need to meet the preponderance of evidence standard, which essentially means more likely than not, or just 51% probability. In plain English, if a tenant's story sounds slightly more believable than yours, you lose. Let me break down how catastrophic this becomes in actual courtrooms. A tenant claims they reported a leaking ceiling to you verbally 3 months ago, but you have no written record of it. You swear you never received that complaint. Under the old rules, the tenant would need to prove the conversation happened. Under the new rules, the judge just has to believe it's more likely than not that the conversation occurred. The tenant provides text messages to friends mentioning the leak, maybe a photo showing water damage, and suddenly their version seems plausible enough. You lose, even though you're telling the truth. Here's another brutal example happening right now. A tenant claims a pest problem existed for months, but you have documentation showing you sent an exterminator quarterly. The tenant shows photos of one cockroach and claims they saw many more that they couldn't photograph. Under the reduced burden of proof, the judge decides it's more likely than not that the problem was worse than your records show. Judgment against you. $19,000. Your only protection. Treat every interaction like you're building a court case, because you are. Require all maintenance requests in writing. Respond to every request in writing with dates and actions taken. Take before and after photos of all repairs. Use timestamp apps and email confirmations. Create a paper trail so overwhelming that even the reduced burden of proof works in your favor. Unsubscribed landlords are losing in court daily. I'm giving you the documentation system that wins cases. Subscribe before you're next on the docket. Number 6, mandatory attorney fee awards. Now we're getting to the provision that's financially crippling landlords across California, even when they haven't done anything seriously wrong. This is the win or lose, you still lose clause, and it's destroying rental property owners who thought they could defend themselves in court. Here's the brutal mathematics. Under California's 2026 law, if a tenant wins their habitability lawsuit, even partially, you are automatically required to pay their attorney fees. We're not talking about a few hundred, we're talking $15,000 to $50,000 in legal costs, on top of whatever damages the court awards. Let me say that again. You could lose a case where the tenant is awarded $10,000 in damages, but you end up paying $35,000 in their attorney fees. Your total loss, $45,000 plus your own legal cost. Here's where it gets absolutely insane. Because tenants don't have to pay attorney fees if they lose. Lawyers are taking these cases on 100% contingency. They have zero financial risk and everything to gain. This has created a lawsuit gold rush, where attorneys are actively soliciting tenants to file claims, knowing that even weak cases can force landlords into expensive settlements. Let me show you the nightmare scenario playing out daily. A tenant files a lawsuit claiming $8,000 in damages over a disputed maintenance issue. You know you're probably right, but your attorney tells you it'll cost $20,000 to defend the case through trial. If you lose, you'll pay the tenants $8,000 judgment, plus their $30,000 in attorney fees, plus your own $20,000 in legal costs. A $58,000 total loss, but if you settle immediately for $15,000 type, you avoid the risk. What do most landlords do? They settle even when they did nothing wrong. This is what lawyers call a forced settlement environment, and it's making landlords walking ATM machines. Tenants know you'll pay to make it go away, so even questionable claims become profitable. Your survival tactic: get landlord liability insurance that covers legal defense costs, that it's no longer optional, it's mandatory survival equipment. Budget $3,000 to $5,000 annually per property for this protection. Consider joining a landlord legal defense fund or association. Most importantly, fix issues immediately so you never end up in court in the first place. Without this channel, you're facing lawsuits blind. I'm exposing the attorney tricks costing landlords millions. Subscribe now or pay later. Number 7. Anti-retaliation provisions with teeth. This is the provision that's trapping landlords in impossible situations where normal business decisions suddenly become $40,000 lawsuits. California's 2026 anti-retaliation rules have created a legal minefield where even legitimate actions can be twisted into massive penalties. Here's the deadly trap. Once a tenant files any habitability complaint, even a minor one, you enter a 180-day protected period where you cannot raise rent, terminate their lease, reduce services, or make any changes that could be perceived as retaliation. And here's the insane part. The law doesn't care about your actual intentions. If the timing looks suspicious, you are presumed guilty of retaliation, and the burden is on you to prove otherwise. Let me show you how devastating this becomes. A landlord in San Jose had a tenant who complained about a slow-draining shower in March. The landlord fixed it within 48 hours. Problem solved, right? Wrong. In June, 3 months later, the landlord sent a rent increase notice that was part of their annual adjustment for all tenants in the building. That one tenant sued for retaliation, claiming the rent increase was punishment for the March complaint. Even though every other tenant got the same increase, even though it was standard practice, the court ruled it looked retaliatory because it happened within the 180-day window. Judgment $33,000 in damages and penalties. Here's another nightmare example. A landlord needed to terminate a month-to-month lease because they were selling the property a completely legal reason, but the tenant had filed a noise complaint about a neighbor 4 months earlier. The tenant sued, claiming retaliation. The landlord had documentation proving the sale was in progress before the complaint, but the timing was close enough that the court sided with the tenant. Lost $27,000 plus the property sale was delayed by 8 months, costing additional tens of thousands. Your protection strategy before taking any action affecting a tenant: rent increases, lease non-renewals, service changes. Check your records for any complaints in the past 6 months. If there were complaints, document independent business reasons for your decision with timestamps proving the decision was made before the complaint. Consider delaying rent increases for complaining tenants until after the 180-day window closes. Yes, and it's unfair, but defending a retaliation lawsuit is far more expensive. Unsubscribed landlords are accidentally committing retaliation daily. Learn the safe moves that protect you legally. Subscribe immediately. Number 8. Third-party inspection rights. Here comes another wallet-draining provision that's catching landlords completely off guard. California's 2026 law now gives tenants the right to demand independent third-party inspections, and you might be forced to pay for them even when they find problems you didn't cause. Here's how this financial trap works. If a tenant suspects habitability issues, they can now request an independent inspector. Not just your contractor, but a licensed third-party professional of their choosing. And here's the kicker. If that inspection finds any violations, you're responsible for paying the inspection fees, which typically run $500 to $2,000 depending on the property size and scope. Plus, whatever they find becomes documented evidence that can be used against you in court. Let me paint you a real-world disaster scenario. A tenant in Sacramento claimed they smelled musty odors and demanded a mold inspection. The landlord's own contractor found no mold issues, just normal humidity. But the tenant wasn't satisfied and hired a third-party environmental inspector who charged $1,800 for extensive testing. The inspector found trace amounts of mold spores, which exist in literally every building, but wrote a report saying elevated levels detected. The tenant sued, claiming health hazards using that report as evidence. The landlord had to pay the $1,800 inspection fee plus $31,000 in lawsuit damages plus their own legal costs. Total loss over $50,000 for a problem that didn't actually exist. Here's the double-edged sword. If you refuse to allow the third-party inspection, the tenant can claim you're hiding something and use your refusal as evidence of negligence in court. But if you allow it, you're essentially giving the tenant's legal team a weapon to use against you, and you're paying for it. Your smart response strategy: when a tenant requests an inspection, immediately hire your own licensed inspector to do a comprehensive evaluation first. Document everything they find or don't find. If the tenant still demands their own inspection, cooperate fully, but have your inspector present during their evaluation. Get everything in writing. If their inspector finds issues, get multiple second opinions before admitting fault. Create a paper trail showing You took the concern seriously and acted professionally. Never refuse an inspection request. It's legal suicide under the new law while missing these inspection protocols. You're writing checks to tenant hired inspectors. Get the insider system that protects you. Subscribe now. Number 9. Cumulative violations multiply damages. Get ready for the most mathematically devastating provision in California's 2026 law. This is what I call the multiplier effect, and it's turning minor maintenance issues into six-figure catastrophes that are literally bankrupting small landlords across the state. Here's the terrifying formula. The new law doesn't just penalize individual violations, it stacks and multiplies them. Each separate habitability issue gets its own penalty. And when you have multiple violations, the damages don't just add up. They compound exponentially. The law treats each issue as a separate offense, allowing tenants to claim damages for each one individually, then add cumulative impact penalties on top. Let me show you a real calculation that'll make your stomach drop. A tenant in Riverside documented 5 minor issues: a dripping faucet, a loose cabinet hinge, inconsistent water pressure, a cracked window pane, and a sticking door lock. Individually, these are $50 to $200 fixes, maybe $800 total in repairs. But under the cumulative violations rule, here's what the lawsuit looked like. Violation number 1, $8,000 in damages. Violation number 2, $7,500. Violation number 3, $9,000. Violation number 4, $6,500. Violation number 5, $8,000. That's $39,000 right there. Then the tenant added cumulative impact damages, claiming that dealing with multiple ongoing issues caused severe stress and reduced quality of life. Another $28,000 plus emotional distress, $12,000. Grand total $79,000 in damages for problems that would have cost under $1,000 to fix. I plus $43,000 in attorney fees. Final bill $122,000. Here's what makes this absolutely catastrophic. The law encourages tenants to document every tiny issue and save them all up for one massive lawsuit instead of reporting problems individually. Why? Because the multiplier effect makes the payout exponentially larger. 3 separate $10,000 lawsuits are worth $30,000. But one lawsuit with 3 violations could be worth $75,000 or more due to cumulative penalties. Your emergency defense plan. Implement a mandatory monthly self-inspection of every unit using a detailed 50-point checklist. Fix everything immediately, even cosmetic issues. Send tenants monthly maintenance update emails asking if they have any concerns whatsoever. The goal is to eliminate the ability for tenants to stockpile violations. Talks. Document that you are proactively maintaining the property. Make it impossible for a tenant to claim you ignored multiple issues. Every day unsubscribed is another violation stacking against you. I'm showing you how to eliminate all exposure points. Subscribe right now. Number 10. Limited landlord defenses eliminated. We've reached the final nail in the coffin. The provision that stripped away virtually every legal defense landlords used to rely on. California's 2026 law has systematically eliminated the protective shields that once gave property owners a fighting chance in court, and this is why winning these lawsuits has become almost impossible. Here's the devastating reality. Under the old rules, landlords had multiple defenses they could raise. You could argue the tenant caused the damage. You could point to ACES clauses in the lease. You could claim the tenant never properly reported the issue. You could demonstrate the problem was due to tenant negligence or normal wear and tear. Every single one of these defenses gone. The new law has systematically gutted them. Well, let me show you how helpless this makes you. A landlord in Bakersfield had a tenant who punched a hole in the wall during a party. There were even witnesses. The tenant then claimed the landlord failed to repair the wall, turning their own damage into a habitability complaint. Under old law, the landlord could have argued, you broke it, you fix it. Under the 2026 law, that defense is inadmissible. The law says once a habitability issue exists, regardless of who caused it, the landlord is responsible. Judgment against the landlord, $23,000. Here's another crushing example. A landlord had tenants sign a lease with an ACES clause for an older property explicitly stating tenants accepted the condition and wouldn't hold the landlord liable for non-critical cosmetic issues. Tenants sued over outdated fixtures and worn flooring. The landlord presented the signed lease in court. The judge ruled that habitability rights cannot be waived, making the clause unenforceable. Lost $18,000 plus attorney fees. Even tenant negligence is no longer a defense. Tenant leaves windows open during rain causing water damage. Your problem. Tenant blocks vents causing HVAC issues. Your snorts problem. Tenants hoarding creates pest problems. Still your problem. Your only remaining strategy, except that you have zero defenses once a lawsuit is filed. Your entire focus must be on prevention. Fix everything instantly. Document obsessively. Respond to complaints within hours, not days. Create systems so airtight that tenants have nothing to complain about. Under this new law, prevention isn't just the best defense, it's the only defense. Your old legal defenses are worthless now. Without this channel's strategies, you will lose in court. Subscribe before it's too late. If you've made it this far, you now understand why thousands of California landlords are facing financial devastation in 2026 and why many are considering selling their properties rather than navigating this legal nightmare. This isn't fear-mongering, this is the cold, hard reality of California's tenant protection landscape, and it's more dangerous than most landlords realize. Let's be crystal clear about what you're facing. $25,000 to $100,000 plus lawsuits over issues you might not even know exist. 180-day retaliation windows that trap you from making normal business decisions. Emotional distress. Damages with no caps. Stacked violations that turn minor problems into six-figure catastrophes. Eliminated legal defenses that leave you completely exposed. Cray and mandatory attorney fee awards that force you to pay even when you try to do everything right. But here's the crucial truth. Knowledge is your only weapon in this fight. The landlords getting destroyed by this law are the ones who don't know it exists or who think their old practices will still protect them. The landlords who are surviving and thriving are the ones who have adapted, who have implemented bulletproof documentation systems, who respond to every issue within 24 hours, and who treat every tenant interaction like a potential court case. 5 immediate actions you must take today. First, audit all properties for any issues from the past 3 years. Second, create a comprehensive documentation system for every maintenance request and response. Third, get landlord liability insurance that covers legal defense costs. Fourth, implement monthly self-inspections using detailed checklists. Fifth, fix everything immediately, no matter how minor it seems. This is not the time to be passive or complacent. This law is actively hunting for landlords who aren't prepared, and the penalties are financially crippling. But with the right systems and proper knowledge, you can protect your investment and avoid becoming another cautionary tale. Your rental business depends on staying informed. Don't let ignorance cost you everything you've built. If this video just saved you from a potential $50,000 plus lawsuit, show your appreciation. Hit that like button right now. Subscribe to this channel because I'm releasing updated California landlord law breakdowns every single week, and missing even one could cost you tens of thousands. What? Drop a comment below and tell me which of these 10 reasons shocked you the most. And if you want to dive deeper into protecting your rental properties, click the video on your screen right now where I break down the exact documentation system that's keeping landlords out of court. Don't wait until you're served with papers. Take action today.